Ladies and gentlemen, I must begin with an apology. Sorry to have disrupted the entire schedule of the conference and have managed to do it single-handedly. Things were out of my control. That's the only excuse I'm going to offer, and not go further than that for reasons particularly which people who practice in Pakistan would be painfully aware of. So, this is supposed to be a keynote speech, ladies and gentlemen. I must begin by thanking the organizers for giving me the opportunity of speaking there. Particular thank you to Rana Sajjad, who has been very persuasive and persistent. Now, if any of you are expecting a learned discourse on arbitration or international arbitration, let me begin by disappointing you. You're not going to get that. One of the sure signs of becoming old is that you reminisce and you tell stories and leave all the hard work to the younger generation and take all the credit for yourself. So I'll reminisce and I'll tell stories. But any discussion about arbitration and arbitration in Pakistan, whether it be local, what we call it domestic, or international, begins with what's wrong with arbitration in Pakistan. That's the constant refrain. You may be in an international conference where the subject is raised, or be discussing it with colleagues before a hearing in an international tribunal, or when you come across an academic paper. A lot has been said about it, and said by persons far more experienced, far more competent, and immeasurably more learned than myself. So let me put that aside. Let me begin for now and pose as a harbinger of good news. And what's the good news? The good news is that even on the bleakest of bleak days, the news is not altogether bad. And think a few years back when a former Chief Justice was in full cry, particularly 2010 onwards, and sanctity of contracts appeared to be nothing but cannon fodder for the juggernaut of suo motu jurisdiction. It was in full swing. Contractual commitments, whether they be national or international, were merely not even impediments, some kind of stones which he kicked aside as he moved forward. In the entire Constitution, the only article which appeared relevant was Article 184, Clause 3, which gives the Supreme Court jurisdiction to suo motu take up any issue. And no Chief Justice had taken that up with so much gusto, and particularly to interfere with concluded contractual commitments than he did. It was along that time, during that bleak period, that the Supreme Court announced its judgment in what is now commonly known as the rental power case. It is, for those of you interested, reported in 2012 Supreme Court Monthly Review 773. And when you look at page 852 and 853 of the judgments, I surely can't read that, and so I'll have something before me, which I can. The Supreme Court, in very unequivocal terms, declared a very large number of contracts, some of them national, some of them international, as void ab initio, regarded them as the products of corruption, said that these were non-transparent, directed the National Accountability Bureau, which continues to grow more famous with every passing day, to take action against everyone, including the ministers involved, the bureaucrats involved, and the men of business involved, and to prosecute them for corruption. The words used were that these contracts were, quote, rescinded forthwith, and all the persons responsible for the same are liable to be dealt with for civil and criminal action in accordance with law. These were regarded as matters for the NAB, and the contracts were all void ab initio. One thought that was the end of the road. All these contracts were dead, and with them were the arbitration clauses. Notwithstanding the fact that an arbitration agreement embedded in a contract is regarded as severable, and notwithstanding the fact that it's supposed to survive the rescission or annulment or a declaration of the contract as void, the Supreme Court's judgment was pretty emphatic, and one couldn't think of anyone who could go around it, particularly in the judiciary. But at that time, in those bleak days, was authored a judgment by Mr. Justice Muni Bakhtar of the Sindh High Court, now a judge of the Supreme Court. At that time, almost 6-7 years ago, much younger than he is now, and a junior judge of the High Court, who looked at the judgment of the Supreme Court and, in spite of it, came to a conclusion in 2014 in a case reported at CLD 337 as Lakhra Power between the same parties, the government of Pakistan on one side and the rental power company on the other, and came to the conclusion that in spite of the declaration of invalidity by the Supreme Court, and in spite of the declaration that it was void ab initio, the arbitration clause in the contract survived, and the parties could go ahead with the arbitration. He looked at the Pakistani law, he looked at the English law, particularly for those of you interested, the cases of Lesotho Highlands and Harbour Assurance, and came to the conclusion that Pakistani law in that respect was no different from English law. And therefore, the contract, in terms at least of the arbitration agreement, was alive, and the parties would not be restrained from proceeding with it. This was followed when it was appealed to a division bench of the High Court, which is a bench of 2 judges, presided over by the then Chief Justice, Mr. Justice Makhdoom, who is now in the Supreme Court, where he refused to interfere with this judgment. And not only that, he directed that the ships, as ordered in the interim order of the ICSID tribunal, should be released and allowed to sail away. So implemented the judgment of the ICSID tribunal in spite of the fact that the Supreme Court had categorically directed that in a subsequent order to the one which I just cited, that the ships were not allowed to sail. And this judgment was not appealed from. And it acquired another life in a confidential proceedings, which I cannot talk about, but this time again the government of Pakistan was in an international arbitration with another investor whose contract again had been declared as void ab initio by the Supreme Court of Pakistan, headed by the then Chief Justice, Mr. Justice Iftikhar Muhammad Chaudhry. And the bench looked at both the judgment in that case and Mr. Justice Muni Bakhtar's judgment, and the tribunal came to the conclusion that Mr. Justice Muni Bakhtar's judgment was a correct enunciation of Pakistani law, and the arbitration agreement would survive such declarations of severability. Now, this is As it said in Lesotho Highlands, this is the ABC or alphabet of international arbitration. But for us, practicing here on the commercial side, it was a major achievement because it was unexpected that a single judge of the High Court will look at a very clear judgment of the Supreme Court and give it a creative interpretation to keep arbitration agreements alive. Now, we also tend to forget, and that's part of the good news, that we have a country, when you think of these in terms of international arbitrations, one of the few which was the creation of a boundary award, where the presiding person was Sir Cyril Ratcliffe. So the two countries, India and Pakistan, were declared independent on 15th August and 14th August respectively. The boundaries, however, were not determined prior to that. The boundaries were determined by this award of 17th August 1947, which came 3 days after independence and continues to demarcate the boundary between the two countries. Now, these are countries which the most of the world regard as sworn enemies, and we do not do much to give a lie to that view either. But in spite of that, not only in terms of the Ratcliffe Award, which was of course something which the British government at that time initiated, thereafter too, there have been a number of disputes which have been settled by international arbitration. The Run of Kutch dispute was settled by an international arbitration of 3 arbitrators sitting in Geneva. Thereafter, the Baglihar dispute went to a neutral expert. That's a sad tale of many tricks having been missed and the neutral expert having done some things which were unexpected. But both parties accepted the award, and thereafter the Kishan-Ganga Award. Huge issue, highly contentious on the distribution of river waters on the basis of the Indus Basin Water Treaty. But both countries went to arbitration, and an arbitration tribunal decided the matter. Now, moving a little away from international arbitration to the domestic scene, and I come back to international arbitration in a little while. For the purposes of this conference and the young lawyers in this conference, the domestic scene in particular needs to be examined a lot more carefully. As one of my friends, a leading arbitration lawyer in the world, said, that international arbitration is to domestic arbitration what a seahorse is to a horse. You have a huge amount of cases being decided domestically, and unless that is reformed, fundamental changes are brought about in that law, it will not be possible to create and educate the next generation of lawyers who are well versed in arbitration. The governing law for domestic disputes still remains, or the governing arbitration law remains, the Arbitration Act of 1940. It was a law designed at that time. This is a law which survived even in England till 1996. It survived in India till about the same time. But now, all around us in the region, changes are, even in the region, changes are taking place, and we need to take a second look. It has a number of problems. When you look at the Arbitration Act, it appears to be geared towards efficiency, but is it? I mean, it requires that the award must be delivered within 4 months. It is very difficult to envisage a situation where you can get the parties to file pleadings, lead evidence, go through cross-examination, and prior to that, production of documents, and have an award delivered in 4 months. But that's okay, that's an ambition, and it has never never bad to be too ambitious or aim too high. But what happens when it is not delivered within 4 months? Then you have to go back to the court to get an extension. And quite often, in many of these cases, the extension is fought over for a much longer period of time than 4 months, inevitably delaying arbitration and giving it a bad name. Besides that, you have Section 30. Section 30 allows the court to set an award aside if the court comes to the conclusion that the arbitrator has misconducted himself or misconducted arbitration proceedings. Now, these are words which could have received a restrictive interpretation, particularly given the changes in the modern world. But these are words which have received a very wide interpretation. And now, over a period of almost 80 years, an almost insurmountable wall of precedent has built around it, where the judges have repeatedly said that if there is an error of law, they will interfere. If evidence has been misread, they will interfere. Where they regard the case as one of no evidence, they will interfere. Now, these are, in a way, innocuous sounding words, but the kind of situations which they govern has created a huge problem, which is that almost any and every award can be set aside, which also means that the parties can challenge it. And given the fact that in Pakistan we are far too well-mannered to award costs, the result is that everything is litigated at least up to the High Court, if not to the Supreme Court. So if you have an award, thereafter you have litigation which may last decades. And if you finally get a decree, then you have the problem of execution. And not now. In the 1930s, the Privy Council observed that the real problems of a decree holder in India begin after he has obtained a decree in his favor from the court. So arbitration has therefore become litigation with an extra round added to it on the domestic scene. And unless that is reformed, that is changed, domestic arbitration will remain hugely problematic. And yet we find a resistance to that change. It is not so much from the judges, but more from the legislators, and partly out of apathy and inaction, and partly because they feel that this law has survived for so many years, so why change it now? But change it must, because if we want investment, if we want to trade with the world, and if we want to seat arbitrations in Pakistan, we must move on and keep pace with the rest of the world. International arbitration and arbitration generally is the engine of modern commerce. And unless we have a working engine, modern commerce will not be attracted to Pakistan, whether it be in the form of trade or investment. We find often in instructions issued by the State Bank, in directions by the Ministry of Finance, that an agreement to arbitrate is all right, but the governing law must be Pakistan law. The applicable arbitration must be under the Arbitration Act 1940, and it must be seated in Pakistan. Whereupon a person from the international market asks one question: if I have a dispute, an award, if I am in the right, and once I have an award, how long will it take to enforce it? To both of these questions, even competent Pakistani lawyers find it very difficult to give an answer or provide a timeline. And we must therefore do something like India has done, probably a little better. The ancestral modern law provides guidance in that respect. But the modern law needs to be tweaked a little to make it a lot more judge-proof. Otherwise, it will have a number of these same problems which you saw happened in India between 1996 and the very recent past. The judges will continue to interpret it like they had interpreted the old statute. And that's not peculiar to Pakistan. It is a worldwide phenomenon. I remember in another century when I was a student in England and reading the law, Michael Zander used to write articles that one thing we must never have for the United Kingdom is a Bill of Rights. Because if we have a Bill of Rights, given the attitude of the English judges, they will interpret it like the tax statutes strictly and make a nonsense of the liberties of citizens. But that's a problem you have to deal with. And careful legislation can help provide the necessary checks. So a little more judge-proof law, but is that all? No, you need a base of young, competent lawyers with a knowledge base, with good skills, who can work with this law, both on the domestic front and internationally. And that's where this organization, which has organized this seminar, and other such organizations which are trying to create a system where things can be made to work for purposes of international arbitration in Pakistan, come in very useful. You may have recourse, and of course we do, and we do it all the time, and employ and engage and retain international law firms when you have an international arbitration problem. But a system never gets accepted. A law never gets accepted. It never takes root in the country and in the people unless you have an indigenously trained body of people who understand it, accept it, are prepared to intelligently apply it, and only then some progress is possible. So the vision which this organization and its organizers have of having a mission for capacity building is a very good start. And please don't be shy about learning or learning from people far more experienced or disclosing that you didn't know much when you started. We all learn in the process. And coming back to my stories, my first one is within the first year of having been employed by the government of Pakistan, I received a call from the law secretary. The law secretary at that time was a serving judge of the High Court who later on went to the Supreme Court. And his knowledge of case law, both local and international, was amazing. And he called me to say, do you know what exit is? And I didn't have the faintest of ideas. So I said, no. And he said, do you know that what is this investment arbitration? And I said, I haven't dealt with it. I have no clue. He said, we have been sued by SGS before exit, and there's an international arbitration claim against it. I said, listen, I don't know anything about the law. He said, it doesn't really matter. You are therefore now in charge. And that's how we started. And so one of the first things I did was, at that time, Google had been invented. So Google it. And when you Google exit in those days, exit used to get as many hits as it gets now. The answer came, there was some kind of International Council for Scientific and Industrial Design. And I thought, what could that have to do with SGS's case? With a little more effort, finally discovered what it was. And no shame in narrating that either, that I made a phone call, and to my great good luck, one of the persons still serving at that time was Mr. Antonio Parra, who has written a wonderful history of exit. And I told him about this case, and I said, this is a case which we have won in Pakistan all the way, and this is a case where the other side took some of the issues to the Swiss courts, and they lost all the way to the Swiss Federal Tribunal. How would you restart it? So he said, well, it can happen. So, but he was a very gentle teacher. He said, I can't presume to advise you, but if you care to look at A, B, C, you will see that some of these things can happen. And that's how we started defending our first case. Now, I came to this case with a background from the private side of having been counsel in the infamous case of Hub Power Company in the late 90s, where Hub's contracts were being interfered with, and the high courts, and later on, the Supreme Court had taken a very negative view of international arbitration and injuncted an ICC arbitration. At that time, working with Hub Power Company, preparing for that ICC arbitration in London, which was aborted because a number of tricks in the trade were used. Number one was an injunction from a civil judge in Islamabad to restrain Hub Power Company, which was a Pakistan company, from arbitrating this dispute. And another was, I will not name it, but an international arbitrator appointed by Pakistan never showed up for the hearing. So there was not much the tribunal could do, not even a truncated tribunal, and they had to adjourn it, which gave enough time for the Pakistan Supreme Court eventually to confirm that injunction. With that background, I did speak to the powers that be, and I said to them that what happens when you use your local courts to sabotage international contracts and international arbitration is that you give the local courts a big bad name. So let's try our luck. Let's see if the field or the pitch has been cleared as much as it is said, as they say. And we started off with SGS in that way, and at the end of the day, the result was not a complete failure. And as I say to my friend Emmanuel Gaya, who appeared for SGS against us in that case, that I owe him a huge debt of gratitude, because he introduced me to an aspect of the law and a side of arbitration and a jurisprudence of which I was blissfully aware of. So we all learn, and we learn in the process by doing cases and reading up and by starting small. You talk to some of the eminent arbitration lawyers and you find that they had started small. Chris Greenwood has no shame in saying that he started his career by arguing bail applications in magistrate courts. And he says that openly and publicly. And Johnny Vida, who was the pupil master of one of the most famous international arbitration lawyers, Toby Landau, says that he had some municipal cases at that time which related basically to collection of garbage, and he used to send Toby to do all of those, and we used to call him garbage lawyer. And you now have one of the most famous international arbitration lawyers in the world. So you start small. They're all, after all, contracts, and they raise the same issues which big international contracts do. And good to learn and practice your skills and hone them in these small cases till you grow. You have, thereafter we had Imprigilo, which we defended and relatively successfully. Then we had Binder, we defended that relatively successfully. And a number of other cases, some of the cases which you who have practiced in the international side will understand. Many people who have practiced domestically, and the government of Pakistan still fails to understand that when they contested Dala, all the way up to the Supreme Court of the United Kingdom won. How did the award get enforced in France, and they ended paying up? But these are the things which, once you initiate the process and you start working with it, which you learn. But there is no shortcut to having a trained, not one team, but many teams of lawyers. And the Attorney General's office for the last few years has done some very good work in that regard. They have a team of dedicated young lawyers, and I have seen some of them, like Ahmed Irfan Aslam, who leads that team, and Mia Shahur Ahmed, who is a member of that team, do wonderful work before international tribunals. At times, they have what Stroke Talbot said about a Pakistani foreign minister, that he had an empty brief, but he also said that he argued it brilliantly. So at times, these gentlemen are not handed over very good briefs, but they make good arguments which make you proud of the fact that the government of Pakistan is finally coming to grips with this aspect of the law. They are using international lawyers, as they must, there's no shame in that, but they're also creating a team of local lawyers which can advise the government. Now, of course, much of the paperwork, as you will see in the Attorney General's office, is still paperwork. But these lawyers will not be there forever. They will gain experience, they will gain maturity, their skills will improve, they have a market, they will move on. But they would have, in the meantime, provided a service, and they can provide a greater service by writing memos, taking notes, and leaving behind them a history of how treaties are negotiated and how disputes are conducted and what are the difficulties they have. And the difficulties are at times insurmountable when you work with the government of a developing country. In the first ICSID dispute, which was a massive dispute at that time for us, some small now, after the CARPE and TCC awards, but it was big at that time. When I asked for the file relating to the governments of Pakistan and Italy so as to see what was the negotiating history of the treaty and to understand the treaty better, I was told that the file was lost. And the story was exactly the same in the case of Impregilo. The file of the negotiating history of the Pakistan-Italian bit could not be found. I thought things would improve when it came to binder, but once again, the file could not be found. Yet, you have to manage. But these days with internet and electronic documentation, probably documents can be maintained better. We did that in one case at least, when we were negotiating with the Americans whether to have or not to have a US-Pakistan BIT. Now it was agreed that everything would be confidential, but a way was found around it by both sides. At the end of the meeting, I would write a long memo to the Prime Minister as to what happened and what we asked for. And the other side would do the same for the USTR head. And a history was created. I don't know whether any of that history is now available or not, but that is one of the steps which can be taken. So once you have created that base, once you have that team of lawyers, how do you go further? How do you catch up with the world? With trying, with experience. And to conclude this conversation, let an old man cite another old man, Henry Kissinger, in his book, Diplomacy. Towards the end, he quotes a Spanish proverb. One person asks the other. He tells the other, but traveler, there are no roads. And then comes the answer, traveler, roads are made by traveling. Thank you.